That is mentioned about this matter. I have spoken to my other side. This has been fixed on 26th August at 2 p.m. I was only beseeching your lordship. It could be taken up at 28th at 2 p.m. I have a leader. We have to argue. It's our appeal. My learned friend thereafter can
For the instruction I have taken from the matter we kept on 26th. If Mr. will not be
then I do not want to waste that time. It could be 28 2 p.m. We will continue with that.
No, on 26th, when it is taken up, you have it mentioned. Yes. You have it mentioned on 26th. Yes.
I was because if
we have heard what you are saying, so we are telling you mention on 26th.
Then you also I don't want to waste that day. That's the only thing. Otherwise, the time will be wasted.
We don't know. We have fixed it with consent of parties on 26th. You can mention when they are not agreeable. Why should be unnecessary? You mention on that.
We are addressing. So if it can be 28 2 p.m., we will start that. That's the only thing.
So therefore, 1 or 2 days you pray on that day. What is the big deal? You can pray on that day. Yes. Yes.
May I take your lordship leave to mention one matter? Lordship, this is an assigned matter. Lordship, I have mentioned it twice. Your lordship have told that the matter will appear in the monthly list of August, lordship, but it has not appeared.
It's for inclusion.
Yes, lordship. Lordship, kindly see there's an urgency in the matter, lordship.
My lord, may I be permitted to mention a matter with the leave of Honorable Justice Bhattacharya. My lord, this is a contempt application by my lord's bench with Honorable Justice Vibhash Ranjan there, my lord. It was due to appear on July 11, my lord, but it is not appearing till now.
Give it.
Lordship, may I be permitted to mention Lordship, may I be permitted to mention for inclusion? Your Lordship, prior direction was to.
My lord, give the slips for inclusion.
My lord, may be permitted to mention a matter. My lord, this is an assigned matter, your lordship. My lord, an appeal arising out of probate proceedings, my lord. My lord, for inclusion and praying for if it could be taken up, my lord. It was mentioned on previous occasions, your lordship. 2021 matter, my lord.
You tell when do you give it? Instruct him when to list.
So great. Praying your assignment.
What assigned matter?
Subject matter bolu.
What is it, sir?
Education group 2 matter.
Why you are mentioning here?
Assign. He's saying assign before your lordships.
Find out if it is assigned. Verify.
My lord, may I be permitted to, my lord, praying your lordship leave to file the writ petition without with the internet photostat copy of the order passed by the learned tribunal. Urgency is that, my lord, disciplinary proceedings initiated against the petitioner. Order has been passed without issuing any charge sheet, without complying the necessary formalities of the disciplinary proceedings.
What is the date of the order?
30th July 2025. I got the internet photostat copy. I prepared the writ petition matter seeking your lordship's leave to file the.
You gave an undertaking.
Yes.
For filing the certified copy.
Yes, absolutely, absolutely.
All right, file it.
Grateful, grateful. It to never.
We are praying for listing the matter. The earlier order passed by this Honorable Court number 1. Appointment matter.
You include it in the monthly list, next monthly list.
My lord, may I mention, my lord?
Much of it.
My lord, today's item number 20, contempt application, my lord. My lord, tomorrow for medical reason, I'll be out of station and I'll be back on 14th August. I'm praying for postponing the contempt application. May I be may be fixed on
Why
18th.
you are here today?
I'm here.
Let us see. All the
All your
Item number 1,
Lordship, I am for the appellant, Lordship. Lordship, on the last occasion, your Lordships directed me to serve upon the learned advocate appearing for the opposite party. We tried to serve him, but he did not accept the letter, saying that he has already, Lordship, given a no objection. He doesn't have any contact with his client.
So there is a matter pending in the trial court.
Yes.
So in his place, nobody is appearing.
The trial court, he is appearing, he is the plaintiff. Because on the last occasion, we have directly served upon the clients. They have received. But your Lordship said that since a learned advocate appeared in this honorable court, we should also serve upon him. He refused to.
On 17th, he was appearing.
Yes, Lordship.
How to ensure? This arises out of?
Lordship, what happened? It arises out of a partition suit, Lordship. The defendant number 1 is the appellant before your Lordship.
Huh?
There are 2 appeals. The defendant number 1 is the appellant before your Lordship. A partition suit was filed. Lordship, in that suit, an order of status quo was passed. Challenging that, Lordship, I have preferred FMA number 1862 of 2019. In the suit, Lordship, I also filed an application under Order 39, Rule 4, saying, Lordship, for this modification of the status quo order, permitting me to construct, Lordship, on a portion, on my portion, Lordship. Now, Lordship, by the order, by the appeal, that application was also rejected, and challenging that order, Lordship, I filed FMA number 1863 of 2019. If your Lordships kindly take up first FMA number 1862 of 2019, Lordship.
Yes.
Lordship, this is the appeal where, Lordship, an order of status quo was passed. Lordship will kindly see order number 21 dated 17th of April 2018, Lordship, later.
Order dated?
Order number 21 dated 17th of April 2018, later. This is, Lordship, FMA number 1862 of 2019.
Where is FMA 1860?
You are the legal heir of? You are the legal heir of?
No, Lordship, what happened? I'm not the legal heir. I purchased the property, Lordship,
From
one of my one of the co-sharers, Lordship.
there were 3 brothers,
Yes.
Chandicharan, Nimai, and Hori Mohan, I
Yes,
think.
Hori Mohan, Lordship.
Hori Mohan.
Nimai sold to Onima. Onima gifted me.
That is you.
Yes.
Oh, acha. Sold to Onima. Onima gifted you.
Yes. Now, Lordship, we say, Lordship, that the suit property constitutes of 16, Lordship, shotak of land. So, Lordship, we are 1/3, Lordship, co-sharer. So, our share comes to
The total area?
5 1/3.
The total area consists of
16 shotak. Because, Lordship, it was 27 shotak. Out of 27, Lordship kindly sees the order impugned, Lordship.
out
It
of
is recorded out of 27 shotak. West Bengal acquired 8 shotak of land.
remaining 19.
Yes. And the share of Chandicharan, 2 shotak was acquired to make drain.
17 remains.
Yes. Defendant on his portion constructed go down. Defendant being the co-sharer has every right, he can and every inches of land apart from the specific sanction has been taken from Panchayat in respect of 775 square feet. So Lordship, their case is that actually the property is 15 shato. They have, if Lordship kindly takes up my application, Lordship, filed in connection with this FMA, Lordship, that is an application for permission of construction, Lordship, CAN 8744. Lordship will kindly come to their plane.
Picture A.
Yes, Lordship, annexure A. Lordship will kindly take up at page 13. It is in Bengali, Lordship. I am reading it out and I am translating, Lordship. Everything is in Bengali in this. Paragraph 4, Lordship.
Uh,
The plain, Lordship. Fourth of the অন্তর্গত
Referring to the plaint.
Yes, Lordship, at page 13, paragraph 4.
I can't even make out which one is paragraph 4.
Lordship, the third line.
Third one.
Third line, yes.
Yes.
I'm Lordship reading and translating for your Lordship. নিম্ন ক তফসিলের অন্তর্গত ক1 সম্পত্তি বাদী বকরি উত্তরাংশ সম্পত্তিতে প্রতিবাদীগণ দখলিদার আছেন। 1 নম্বর প্রতিবাদীর ভাগিনী অনিমা মণ্ডল ক সম্পত্তির মধ্যস্থলে 5 শতক জৈনিক পূর্ববাদী নিমাই চক্রবর্তীর নিকট খরিদ করিয়া এবং পরে 1 নম্বর প্রতিবাদী উক্ত মধ্যস্থলের 5 শতক তাহার ভগিনী অনিমা মণ্ডলের নিকট খরিদ করিয়া প্রকাশ করিতেছেন। It means, Lordship, in the middle portion, Lordship, one Anima Mondol purchased the property from Nimai Chakraborty. And
Your vendor or the person who gifted it to you.
thereafter, he gifted our client, Lordship, that is the first Protibadi, that is the first defendant, Lordship. Here, Anima is his sister, and Anima gifted this to the defendant number 1. So, Lordship, he also says that 5 shatok of land. So, Lordship, the plain case is that at least 5 shatok belongs to me in the middle portion. This is undisputed. We say that, Lordship, in our statement that we actually have more than 5 shatok. But at least respect of 5 shatok in the middle portion, that is admitted. Now, Lordship, 5 shatok, 1 shatok is average, Lordship, in average 435.6 square feet. And Lordship, in the impugned order, it is stated that we want to make construction in respect of around, Lordship, 770 square feet. That means around 2 shatok. So, Lordship, they are admitting that we, in the middle portion, we have 5 shatok. Out of that, only in respect of 2 shatok, Lordship, we want to construct. And that too, Lordship, for our dwelling house. So, Lordship, that permission may be given. Even, Lordship, we have given an undertaking that if later on it is allotted to some other co-sharers, we will, Lordship, just dismantle the construction. Lordship will kindly come to page 6 of my application. In paragraph 9.
Yeah. In their presence, it will be proper to pass the order.
If they are not appearing, then, Lordship, may I
Make one endeavor upon the lawyer representing them in the trial court. At least serve one copy to them. The
Item number 3.
Grant a short passover. Short passover.
In which case? Has been called. No short Passover, not today. Not today. Next.
What is the name?
Item number 4.
But this matter was heard by your lordship on while your lordship was taking up the order for matter. Now
I'm for the respondent, my lord. My lord, the matter has come and complete surprise to me, my lord. Notice to my part.
We are equally surprised.
I'm not blaming him, my lord. But he's my best friend, my lord, in school life, and I cannot blame him. But lord, your thing
So it's
is,
parted matter.
what happened? Your now it is assigned.
I have not.
Now what happened, my lord? Your
Brief also, my lord. Can it be taken up?
Wait, let me.
what happened? Your lordship heard the matter. Matter was heard at length by both of your lordship, my lord. Matter was directed to appear as 4 orders.
Oh.
Subsequently, bench has been changed. Matter came up before the another coordinate bench. Before another coordinate bench, then when your lordship has heard the matter at length or 3 days, the honorable bench, my lord, presided by Justice Tandon, released the matter. Now matter has been assigned before your lordship. Now, my lord, if
You will have to take pen again. What can be done? It's what is the last date of hearing?
last date before
About a year back,
July to yes.
August 24. We will have to take the pen.
Only difficulty, my lord, I have no problem if
You decide between you when you want it.
only thing Saturday I wrote a letter in the court below, executing court, saying that the matter, this is the situation. Now the executing court has fixed the date on this Saturday as a last chance. If I will definitely pray for an accommodation. If my learned friend did not oppose in the court bill, I have no problem in the next week.
Agree to a date, we will hear it.
The meantime, if the matter is taken up on Wednesday or Thursday, my lord.
আজকে মঙ্গলবার তো।
This week.
This week, my lord. On
This week.
Saturday, the date is fixed, my lord.
This week cannot be.
Although in the,
The
order,
matter is pending since long, my lord.
Right.
No
He knows
endeavor
better.
was taken to enlist the matter by this time.
possibly
my lord.
this is not right because my lord, matter has been after assignment. This matter has been mentioned. Subsequently, Fata has gone down to the department. Then it has come. Now, although in the order for 10, he don't have any right of
On
audience.
next Saturday, my lord, I may, my lord, pursue that so that the adjournment petition may not be opposed. But thereafter, it is difficult for me to pursue.
So we'll fix it in the coming week. On Thursday.
Only
Thursday.
only thing, my lord, kindly give me a liberty to pray for adjournment because if the writ has been issued, nothing will remain in this appeal.
Thursday is
But
7.
I will convey, my lord, don't record that order, my lord, I shall convey. And I shall convey it, my lord. Because if appeal has not yet been admitted, my lord. At this stage, my lord, if this kind of order, my lord, that will the difficulty is this. Once the order is passed, that will be my lord. That will be used, my lord, for long if the matter is not, my lord.
Lordship is fixing the matter next week as a top of.
Saturday, my lord, I will certainly, my lord, convey that so that if he prays for, but don't, my lord, don't record an order, my lord. I am taking the responsibility on Saturday, my lord. I am taking this for this Saturday, coming Saturday. My lord, don't.
Unless we admit, we cannot pass an interim order.
I'm not. I never prayed for an interim order. I said, kindly permit me to communicate your lordship's order. Your lordship is fixing the matter on next week.
We are passing the order. You can do whatever. The
I'm
party,
not trying
the
to.
learned counsel for the appellate.
Taking the
I will convey, my lord. Once the liberty
to have it before.
এই তাহলে তাহলে তুই কর আমি করছি তাহলে আমরা করছি তো আমি
Let it come. Yes, 14th.
But he assured before your lordship will not oppose.
I will convey my lord. I will convey.
You will get the order today.
Years that, 2 years the execution can adjourn under 1 day. I don't think my lord the thing will go another way.
Item number 6.
Application, your lordship directed us to file the medical reports.
I've already filed the report of the SP Purva Midnapur, person to Malad.
What is it? What is the matter?
Okay, I'll tell you. Let's take it from a moment.
Excuse me.
Okay, this is the matter relating to transfer of the
Then we have given. Yes. So the transfer order or first October 24 is the subject.
Okay. Okay, that apart on the
When
last,
is that order?
Okay.
It's a chain transfer.
okay, coming to your Lordship, on the last occasion, your Lordship was pleased to direct us to file the medical reports as to regarding the mental state of the petitioner. Lordship, we have filed it by way of a supplementary affidavit and we have served a copy on the other side. We've already served a copy on the other side. Lordship, I requested for, Lordship will kindly come to page 8, Lordship, of my supplementary affidavit. To the medical, page 9, P8, page 9. The medical superintendent cum vice principal, NRS Medical College and Hospital, AGC Boston. Sanjay Rana joined this police district on transfer from such and such. He submitted several intimations citing serious health issues as a reason of his late joining. Subsequently, he again reported sick and remained absent for another 75 days. During his absence, he sent multiple intimations to his office mentioning various health issues. After joining, the said officer prayed for office posting and light duty due to his persistent poor health condition. In the light of his request, it is necessary to examine his health condition, whether he is fit for performing duties or not. It is also pertinent to let this office know whether his illness is temporary or likely to recover within a reasonable period. Under these circumstances, you are requested to arrange a medical board under your esteemed authority to examine the health condition of above-mentioned officer and furnish a report in this regard. Furthermore, you are requested to schedule a date, time, and venue for the above medical examination, such and such forth. Lordship, then we have a next page. We have a telegraphic intimation, and then we have the government West Bengal memo, page 11. You are hereby requested to inform Sri Sanjay Rana to visit the General Medicine Orthopedical Psychiatry at 10:30 a.m. within 26/2005 for his various medical checkups, and to intimate the same to the designated personnel of the Zonal Medical Board attached to such and such. The incumbent may be requested to bring all previous medical reports, records, and original in support of his or her illness. Now, Lordship, this is page 12. You find the report of the medical board. So may I come to page 12? Certified by psychiatrist specialist. Subject attended on 7/7 FM with wife and mother. Got by attending officer, informant wife. History, mild disturbance, abnormal behavior, and suicidal attempts. Occasional low feeling. He's taking psychotic medication for last 6 months, prescribed by private psychiatrists and neurologists. As per history, clinical evaluation, and psychology
Has been done.
24/6. No major psychotic disorder can be deferred. He is suffering from mixed anxiety and depressive disorder on day. He has to continue psychotherapy medication under supervision. He is fit to continue duty without arms. Under complete supervision, the patient party also requested to keep constant watch. Is advised to attend PD after 8 with reliable informant and a note from the superior officer regarding SOS, his behavior in between.
Yes.
Lordship is prescribed.
So far, that's why, that's why the tribunal directed that there should be counseling.
No, the tribunal's direction is least said the better. The
Yes.
tribunal has no jurisdiction to say.
The psychiatric, but I'm not making it.
That is totally uncalled for observation by the tribunal. You are there to decide the matter in law and just part with it. Why should you say that he needs counseling? Anyway, he has now been examined by a
medical
The opinion is he has no psychiatric disorder.
Yes.
The opinion is he's having some depression and things like that. And he's on psychotropic substance drugs also.
Okay.
So and that has to be continued.
Yes.
That is the opinion of the doctor who is board. Four doctors, five doctors, four doctors have examined him. And they say that he has to be given a posting without arms under supervision. So in view of that, now you have to take a decision in terms of the medical opinion.
Yes, and he has joined on 16th of May 2025.
We don't know all that.
No, that I have written instructions from the.
So he has joined. We were anxious to know whether he has joined or not. He has joined.
Joined on 16th of May.
Whenever. So whatever is the consequence, that we are not concerned with. We are only concerned with the transfer order. Now you have to take a decision in terms of the medical board.
Yes.
That is all.
The law says, I'm not really prepared today because it's a change brief, but as per the rules, Lordship, he can be transferred on medical grounds to his hometown. I'll play.
We are not going to direct that you be transferred here and there. We are being very clear. There is a medical opinion. It is for them to consider. The medical opinion is by the state. State will consider and it will give a posting. Why home? It says posting under supervision.
Supervision, Lordship, obviously means supervision by the family members.
We don't know. We are not going to enter that. That's not the issue here. The issue is whether that transfer order can sustain or not. Your case is that you have been transferred 10 times in the last 3 years. That is your case. 10. In the OA, you have said 10 transfers in the last 3 years. And they say that you have been out of line. You are talking to the press. You are doing this, that. You are in a uniform service. This is the rival submissions. As of today, there is a medical opinion. This has to prevail over everything.
Yes.
So now they have to take a decision. If you are aggrieved, then you may, whatever, we don't know.
Let this matter be kept pending.
Oh, surely not. Now it is for them to decide why the matter should be kept.
Let them take a decision. If
They will take a decision.
Will come before your Lordship again.
We don't know. We don't know whether you will come here, you will go to the tribunal, whether you will be satisfied. We can't presume that the posting will be not to your satisfaction. As of today, how can we? There is an opinion, they will take the decision. Who is the competent person for posting?
DIG. Even
DIG.
Even where he was first posted, that would suffice, Lordship.
The transfer order taka diye the dekha. Transfer order ta transfer order.
This to be taken into consideration for its conduct in respect to month we have been
To kindly come to pastoral once, the patient party is also requested to keep constant watch.
Administration. DIG administration.
he is a respondent.
Just give me. DIG administration, but because state is a party, but
Number 6.
respondent number 6.
So you see, not only do you take a decision regarding his posting in as per this, but this opinion covers a period of about 6 months prior to the day on which he has been examined. So anything you do for this period, it has to be keeping in view the medical.
Consider the medical
Yes.
report.
Yes.
Considering the medical report.
So whatever he has done in the past 6 months, it should be covered by this report. Yes. Take the petitioner.
Item number 7.
And it was taken up for consideration yesterday.
Yes.
Final order has not been passed. I came before this court.
Yes.
Remember, and the order which has been passed by the division bench.
What is the impugned order before the tribunal?
I tell you, I mean, there is a policy of the promotions from group E to group C. There is also rules that everybody will have to complete the examination and type test and computer test they will have to pass. Now the private respondents without passing that typing test, they are government authorities are giving promotion them, so getting our time. We have been tested. That was the main prayer before the court. And well, it was adjourned from time to time for various days. And lastly, I came before this court. One of the before High Court, I am not well. Your lordship was of the view that every time I am coming. Well, it was not adjourned. Lastly, the division bench passed an order, page 157, if your lordship kindly. Today, the final order, I am not coming under the final order. Only, my lord, the posting, the matter was directed to be heard in the month of December. And in the meantime, they have published and notifications that they are in violation of the rules. They have taken a special consideration for giving promotions. Your lordship can take 157 of the way, the WPST, order dated 6/6/2023. তারপরে কোনটা কোনটা হচ্ছে?
Lordship, yes. Lordship, I would like to point out that the reply has been filed. Yesterday, I could not bring this fact before your lordship. Opposition has been filed by the state before the tribunal.
And during the pendency of the application, similar, they have published a notification, page 53. Intended for
So where are the two impugned orders, 23/7/19 and 24/7/20? Where are they?
Mr. Chakraborty is leading me in this matter phonetically.
Yes, where is it?
In order of the tribunal?
No, you have challenged two orders, 23/7/19 and 24/7/2020 before the tribunal. Where is this order? You have not filed it.
Is 139. Well, I'm extremely sorry that that is not clearly legible.
Not clearly legible.
It
It is just a smear. It is nothing. So how do you expect us to examine the issue?
139 and 146.
Why you file an writ petition like this? If you don't want us to consider, then keep it pending. Let it remain pending.
We should have been, well, it is extremely kindly excuse us, it is our fault. Well, the time for me, right? Ought to have been.
All your annexures are like that. How do you expect anybody to understand what is going on? You have not seen also before coming to court, otherwise you would have known. What is this? Issue arises from these two orders. Only therefore after anything can come into. We can't just take off directly without.
No, I am not looked at the merit of the matter today. I will at the application lordship, whether the tribunal can fix up the date in the month of December.
We are looking at it right now. What do you want? What is your relief now? What is wrong with these two orders? Tell us.
I tell you.
Yes.
But I'm extremely sorry. Well, kindly excuse us with the time for to have been supplied to the court. It is our fault that we committed.
No, the worst thing is that even before coming to court, you have not seen it. It may not have been filed, but at least before coming to court, you should have seen it. That is the impugned order before the tribunal. Neither you know what it is, nor we can know what it is. And we are considering the matter unique circumstance.
Under the promotion order, which has been granted to the private respondent without parting the time.
How do we know? How can we say? Tell us.
Because of the fact they have.
Yes.
They have issued an order during the pendency of the writ application. If the lordship kindly order to that. If the lordship kindly have looked to the application for interim order, page 53, it will be clear.
It is under which rule? Where is the rule provision?
Page 86 of the original application. The notice had. That will be the problem. Of the
Take down. DOA. We know these things happen, but at least before coming to court, you would have realized. Yes, please. All right. File it. Give them a copy also.
The private respondents also whose promotions have been.
We'll see.
Yesterday,
Item number 8.
my lord, 8 is restoration application. My lord, yesterday my senior has mentioned it. Kindly allow the restoration application, my lord, and fix a date for hearing, my lord.
For restoration, fix a date.
No, my lord, kindly allow the restoration application and fix a date, my lord.
Where is the restoration? What is the CAN number?
And number 2, my lord. 2. Other matter was mentioned with this matter, my lord, of similar standing. It is not appearing in the list. Last occasion when it was called, we could not appear in this matter. As this is a changed brief, my lord.
You are the only respondent.
Yes.
The CAN application has been, the CAN has been filed for restoration. Back to the department. I don't know what is the process.
Subject to correction, my lord, this may come under the heading of adjourned motion, subject to correction, because in the department, since your lordship has restored this matter, so it is there in the original file itself. So it will be
So any contra entry is not required to be taken anywhere.
subject to correction, no. Subject to correction.
I don't know what is the situation. It will go back. It will go back to the department. No. List after 2-3 weeks.
My lord, WPCT 205, Prabhanjan Jariyat, my lord. This is also similar kind of matter with this. It can be tagged together so that it can be heard together.
Because, my lord, this common order was passed in respect of these two incumbents, my lord.
So the other rate is still pending. Where is that?
Lying with the department, the file is lying in the
না,
department.
এখানে আছে কিনা দেখে নিন।
এখানে
ইয়ার নাম্বারটা দিয়ে দিন।
WPCT 205 of 2020.
Where is it, madam? Is it on the list or it?
No, it is not in the list.
Then give a slip.
Yes.
Madam, I have already mentioned it once with this.
All right, so we should now refer to what, when you have mentioned, and try to find out the details
No, no,
so that it can be tagged with this matter. We will try.
no, no,
Yes.
Item number 9.
Appearing on behalf of the petitioner, your lordship, actually the recorded advocate of the petitioner is C, and due to his sickness, he is unable to attend before your lordship. Kindly adjourn the matter today.
Let us see.
Lordship, Mr. Top.
Yes, very good. You are for?
For petitioner, your lordship. Mr. Manik Poddar is ill, and due to his illness, he did not.
Why it has come on the list?
Lordship, fix it. Just today.
Why it has come on? The writ petition was already allowed. Why it has come on the list?
So far, regarding the matter, I have no knowledge regarding the same, your lordship. So, your lordship, kindly adjourn the matter to and fix the matter tomorrow, your lordship.
Already allowed. It has come on the list.
आज के नहीं मानिक का शरीर खराब हो जाए
Me. Four. Yeah. Why the application has been filed?
They have filed an application for transmission of the order. They want a practically review of the order passed by your office, which is not published. My lord, dispose of the application.
Also kindly fix it tomorrow, your lordship.
Lord, deputed the entire case 22.
What happened? Not today. This will be taken up tomorrow. Tomorrow. Probably.
Item number 10.
Incorporate some other.
This is the restoration application, my lord. And this is the affidavit of sale. The WPST number 222 of 2024 was dismissed by an order dated 6th December. And my lord, on that very day, my lord, I was being treated to the emergency medical facility of this honorable court, and thereafter, my lord, I was continuously treated, my lord, till 31st December.
Yes, you are appearing. Yes, take down. Restoration. Why you are filing a section 5? 1 and 2. 1 and 2 both are
Abundant caution.
too much.
Our full bench Supreme Court had decided that no limitation act does not apply to the request.
Cannot
Yes,
delay and latches, that is
Item number 11.
Yes. Within time. Yeah. Yes. Yes, it can. Within what day? Things of check of time. Petition is not. Is a discretionary. See whether can be or it right does can be applied. Even if it does after 2 years, like they have done in that case for 14 years. Then
12 হবে না।
Well, can you see the order passed by your lordship on 5th December 2024?
My lord, this is my application, my lord.
What is the ground for this?
Yes, my lord, I have stated the grounds in my review. My lord, it is a very short, my lord, I would like to place, because your lordships has been pleased to hold that primarily since the issue was
No
decided-
rehearing. What is the ground for relief in a review?
I state this, my lord.
Yes.
My lord, the issue is this, that your lordships have been pleased
Come to
hold-
the order. What is the error apparent on the face of the order?
My lord,
Tell us.
I place before your
We are not going to allow you to re-argue the matter.
No, my lord,
Please be very
my
careful.
lord, I will not be re-arguing the
Yes.
matter. Lord, the only
You are trying to convince us that it is a case for interest. We are not going to allow you to do that.
I shall.
Yes.
Let me just place it, my lord.
Why? That's not the scope of a review. There is no, if an argument is required, there is no scope for review. That is the law.
My lord, I will not be arguing.
Show us from the order only.
Only one thing, my lord.
Yes.
While the matter was being decided, my lord, the honorable court, my lord, the honorable bench, my lord, had come to a finding that the issue of interest was adjudicated by the learned tribunal.
No, we have not. We have said you have raised, there is no order on that.
Yes, my lord. This is where
There is no question of adjudication.
my lord, this is where, my lord, I am
Yes.
saying this, my
So
lord.
therefore, no rehearing.
My lord, if an issue was raised, but if it has not been adjudicated, my lord, I would like to place one decision, my lord.
What is the decision on the scope of review?
The scope that if an issue
See,
has
please,
not-
we are telling you, we are not going to allow you to re-argue the
my
matter.
lord, this is only the law point, my lord, which I will be
Which is, it is on the scope of review.
It's on the scope that if an issue which has been raised, but if it has not been decided,
Yes.
my lord, then it is not barred by res judicata.
Third learned counsel for the petitioner and the learned. Don't encourage these things at all.
My lord,
Call the next.
my lord, let me go back to the tribunal and
Sorry,
getting a review.
next case. 12.
My lord, that liberty may kindly be given.
Sorry.
My lord.
Your Lordship, for item number 12, Mr. Arpo Chakravarti is appearing for the petition. Due to some medical emergency, he is out of station, Your Lordship. I am praying for only 1 week accommodation.
Review. Yes.
What is the issue? Tell us.
Your Lordship, for this matter, Arpo Chakravarti is appearing for the petition. For this matter, Mr. Arpo Chakravarti is appearing for the petition, Your Lordship. He is out of station due to some medical emergency, Your Lordship. I am praying for 1 week accommodation, Your Lordship.
Learned counsel for the review petitioner seeks an adjournment list after.
Item number 13.
In this matter, my learned junior, Mr. Harishankar Chattopadhyay, for the petition. But my lord, since he has been stranded, my lord, the mantle has fallen on me. My lord, the mantle, I'm.
Your junior is online. Yes, so doesn't matter. You can proceed.
The mantle has fallen. My lord, it is open. Or 245. And my lord,
The item number 13. Review. 13. Review of which order? Huh?
well, I'm not on review, my lord. Unless section 5 is allowed, my lord.
Am I audible?
Yes.
Audible, my lord. My video is not coming.
Why are you, when you have a learned senior advocate representing you, why
My
you
lord,
are?
I was present whole day yesterday, and I come from very long
Both of
distance.
you will make submissions for the petitioner.
My lord, I'm indisposed today. I told him last night only. I requested my senior last night only.
What is
The
this?
can one
He's saying
can,
he is leading you, and you are saying you asked him to take an adjournment.
my lord, only can one is to be required. You had
What
today,
can one?
Can for condoning delay, my lord. The condoning there is a 58 days delay only in filing the review application, my lord. Can one should be taken today only, and we have not
Serve a copy.
we have not served the copies to the other side, my lord.
Serve a copy. Let copy of the can application be served.
Unless can is allowed, my lord, we cannot serve.
President Debt.
Here is my copy. Here is my. नहीं देखो देखो हाँ
Just filed it. Why it is not tagged before the case is taken up? Yes.
My lord, can has been filed in the department.
Yes.
Item number 14.
Item 14, but I am appearing for the petitioner. This is an applications for review pursuant to a lordship's order dated 24th March 2025. Whereas the writ petition was heard before a lordships. Then after, this is the affidavit of service may be kept with the record. I am appearing for the state in this.
Yes. What is the error apparent on the face of the record?
Pardon?
What is the error apparent on the face of the record?
Face of the record that means your lordship. From that ground, that the
We are not going to reconsider the ground. Please be very conscious. You are arguing a review. What is the error apparent on the face of the record? So from the order.
maybe see the order.
In every case, you file a review, very unique practice.
No, well, according to the
We are not going to allow a rehearing. Be very conscious. We are not going to allow rehearing at all.
I know that, my lord.
Yes.
So far this review petition is concerned.
So therefore, you should not.
Apparent, my lord, facts and circumstances of the case, my lord, after
No, we are not going to look into the facts and circumstances.
No, I am not. No, fact.
Yes.
It has been, my lord, at the material point of time when this matter was, my lord, your lordship heard this matter and observed that the petitioner is a irregular appointment.
All right. Hard learned advocate. Next.
But your lordship, my lord,
Item number
kindly, my lord,
15.
not to dismiss because, my lord, the on
15,
merit,
my
my
lord,
lord,
I
we
am
filed this
for
review
the
petition.
respondents.
Lord, item
Same.
number 15, I am appearing on behalf of Public Service Commission.
The ingredients of order 47 has not been, my lord, in this order has lordship has clearly held prior application. They have not chosen anything, and accordingly, lordship has, in terms of that, lordship has passed the order. So, what is the error in this order, my lord?
Even if there is error, this is not the jurisdiction. If the error is there, you have to go in the appropriate jurisdiction. Why you file a review, sir?
My humble service that approach the honorable tribunal after the order passed by this honorable body, and tribunal passed an order on merit, and against that I approach the honorable court WPC. This honorable court held in WPC 64, there is a separate cause of action, and I have to go before the tribunal, and I have before the tribunal, and tribunal passed an order on merit, my lord. And when I approached this honorable court, my petition was not considered as before the in 64 it was rejected. That is res judicata. It is not according to me, my lord, my humble submission is not a res judicata.
All right. Learned advocate for the petitioner, sir.
Review application.
16.
Petitioner my humble submission, item number 20, contempt application may be heard together because in that respect only.
This is an application for review of the order passed by your lordship. Only
In this case, contempt has been filed, which is at 20.
Item number 20.
but that depends upon the reviewer. Only one ground, my lord, before the decision on 7th December 2024, relying on circular dated 20th February 1996, which is not applicable to the writ petitioner because it is a different department. Kindly see page 90 of the order, page 22 of the order passed by your lordship.
This fee is taken earlier also, my lord.
No.
That's also discussed in the order. It's reflected in the order, my lord's
Later.
order.
My lord, rely upon and set aside the order. Kindly see that 20th February 1996 circular, that is at page 92. He is not under the agricultural department. He is under the irrigation and water department. Yes, sir. Only one ground. This is a
Filing a contempt application, he has come with this ground.
You are appearing for the respondent.
only one ground, my lord. My lord relied upon the circular of 1996.
Yes, we have relied on that.
But this circular does not apply to him.
We don't know. That may be a wrong. That's not an error of the record. That's not an error of record.
Error on the face of the record.
How?
My lord, while considering this circular, but this circular on this.
So you are doubting, you are challenging the correctness of the order because it is relying on this circular.
But if this circular is not applicable to him, my lord was correct in passing the order. But if this circular is applicable to him, but according to this circular is applicable only to the director of the.
No.
Except
There is no such submission made by you.
Sir,
There is no such submission made by you. Show us from the order where you have said that this is not applicable.
And the two combinations dated 10th January 22 and 6th April 22 issued by the authorities to unsustainable for the documented
This is not your case that it is not applicable.
today and
Today you can say anything. Therefore, it is not an error of record.
for a moment whether this applicable to her or
We are not going to rehear the matter, please. We are asking you to show an error apparent on the face of the record. Yes.
Only when these my lord has relied upon 20th February 1996 circular and set aside the interim order.
Yes.
But if this circular is not applicable, whether it could be applied in case of other.
So therefore we are asking you, what is the error? Where have you taken this ground that we have not considered?
Yes, in ground number 1, only one ground.
Not in review. Where was this ground in the writ that we have committed an error of record?
In the tribunal, we have not filed it.
In the writ petition you have filed?
But in the petition, we have agreed to from the date of joint.
Hmm?
Irrespective of any sir. We agreed to give synergy from the date of joint.
We are asking you, where is this ground taken that you are saying it is an error apparent on the face of record? You have not taken any ground before in the writ proceedings. How you can now take a new ground in a review?
That means the order applicable.
Hmm?
Order was passed in our favor by the learned travelers.
In the writ proceeding, we are asking you. In the writ proceeding, you have filed an opposition. So where is this ground taken that this is not applicable? Then
No.
Then where is the error apparent on the face of the record? Sorry. So you want to re-argue the matter essentially? Yes. Yes, you want to re-argue the matter. Is substantially it is the same thing.
Only this circular is not applicable.
We don't know. There's no ground on this. No such issue was raised in the writ proceeding. No, kindly see your opposition. If you have not taken this ground, where is the question of looking into it now? Will that be covered by a review jurisdiction? You tell us the law that a ground which you have not taken, you can be permitted to raise in a review. Show us.
Order is not applicable. But it is an error or subsequent.
Show us. Show us. That no such ground taken for the first time in review, and on that basis it will constitute an error apparent on the face of the record for invoking the principles of Order 47 Rule 1. Show us. Which full bench? Where is it? All right, come tomorrow.
I will not be available, my lord.
You won't be available.
I'll
Till
be out
when?
of station, for medical reason from tomorrow to till 14th August.
14th.
My humble submission is, my lord.
The learned
Order
AGP.
11-12
Give your appearance in 20 also. You are appearing in 20.
Item number 17.
Item 17, I am appearing for the petitioner. This is my contempt application against your lordship dated 19 July 2024. On the last occasion, we were directed to effect service upon them, lordship. Give a notice.
My lord, I am
The
appearing,
service was effected earlier, lordship.
my lord, I am appearing for the alleged contemners, my lord. My lord, they had served, I suppose we had not received it. So now they have served in court.
File an affidavit.
My lord, we'll file a compliance report. My lord, will kindly give me 3 weeks time because the client resides in Gujarat.
3 weeks. A copy of the contempt application.
Yes, Lordship. Yes, Lordship. That's it.
Well, I'll satisfy your lordship on that.
Grateful.
Item number 19.
My senior Pampade Dhawal, she is engaged in court number 25, my lordship. I am praying for a short passover.
You're for the state.
My information order has been complied. On 8th of July, there is some delay.
Why don't you file the, you have instruction? Show us.
What he has received.
Yes, they have paid the salary.
I've already supplied.
What remains?
My lordship, I am praying for a short passover, my lordship. My senior is engaged in 25, my lordship. Kindly allow, my lordship. Hmm.
They have paid that 10. Let him file it, give it to them. We are informed by the learned AGP that
Item number 21.
If I'm appearing for the petitioner, the order was passed by your lordship on 2nd January 2025, whereby your lordship has directed the respondent authority to as the petitioner temporary service was qualified as for the granting pension, but I have communicated the order to the respondent authorities as well as contempt notice was issued, but no action has yet been taken by the respondent authority, Your Lordship. Page 51, relevant portion, para 25, Lordship.
Let notice be served on the respondents and affidavit of service.
Twenty-two.
My lord, 22, my lord, I am for the petitioner, my lord. My lord, order is at page 28, the order in portion. Relevant is paragraph 6, my lord. Your lordship directed the petitioner to file an appeal within a period of 3 weeks. And if that is filed, my lord, within a period of 4 weeks, they will dispose it of. In the event it is not done, I should be allowed to join, my lord. I have preferred the appeal. Within 4 weeks, no reply was given. Only one notice was served upon us after 4 weeks that you prefer appeal in terms of so and so rules. That is the only thing. After 4 weeks, it was served. I applied before my joining authority to allow me to join. It has not been. My lord, page 28, paragraph 6. My lord, thereafter, my appeal is 30. I have paid for it.
You should serve, let notice be served on the respondent.
Twenty-three. 3 to 25.
Respondent, Mal.
That's why I remember.
This is pertaining to, my lord, an order in the disciplinary proceeding, my lord, dismissing me from the service. And after that, my lord, I challenged that before the learned tribunal, basically on the ground of non-examination of the vital witnesses, and my lord, the other several other grounds, my lord. The termination was set aside, and I was directed to be reinstated. And my lord, it was also directed that the fresh inquiry proceeding should be initiated against me. Or challenging that, my lord, the Union of India has preferred this writ petition before this honorable court. My lord, I must apprise to your lordship candidly that in this meantime, I was reinstated, and my lord, fresh inquiries also started against me.
7.
May I hand up your lordship this subsequent development to your lordship?
He is not here. What is to be done?
Yes.
Today.
Into the respondent. Into the respondent.
26.
My application.
My lord, this is an application, my lord, receiving the order dated 18th of August 2008, whereby the, my lord, learned tribunal, my lord, partly allowed my application, so directed for refund of the overdrawal amount that was deducted from my gratuity, but my lord refused to, my lord, denied to, my lord, direct for refixation of the payment. What happened, my lord? In this case, my lord, I was appointed as a lower division assistant in 1964.
So that amount has been deducted, refunded to you. And what was the prayer in the OA?
Page 63, my lord.
Why you are deprived?
My lord, what happened, my lord, when I was promoted to the post of superintendent from the post of additional superintendent? My lord, they say that, my lord, that was not a promotion under the West Bengal service rule. They cited a particular service rule, that is rule 54. My lord, the LR has repeatedly said that this is a promotional post from additional superintendent to the post of superintendent in the office of legal remembrancer. It is a promotional post, but my lord, the finance department as well as the, my lord, the office of the accountant general declined that. They said that this is not a promotion. My lord, I will, my lord, try to, my lord, place your lordship at least 3 letters.
So this, but this relief that it is, you are to be granted a promotional benefit, that has not been paid by you.
That was, my lord, if your lordship kindly considers the prayer A, my lord.
Yes.
My lord, because my representation on the basis of which, my lord, I approach the tribunal.
No, you are claiming benefit of revision. You are not claiming benefit of the promotional post. Your prayer A is for the benefit of revision.
Revision of pay, my lord.
This is not for the promotional benefit. Then how it can be granted by the tribunal? Then that is not a case set out by you in the way. Then how it could have been granted to you?
Presentation that, my lord, I submitted on 18th of July, which was declined, on the basis of which I approached the tribunal, my lord. If your lordship may kindly see, is my lord, page 36 and 39. And my lord, I will place, my lord, the objection raised.
The entire case is about revision. We are going through your OA.
in the history of this particular department, legal remembrancer, I was the only, my lord, superintendent who was not granted the benefit. Previous to me and post my superannuation, my lord, all persons who had been a superintendent had been granted the, my lord, benefit of promotional, 7 except me. And that will, my lord, transfer from the letter submitted by the legal remembrancer repeatedly. This was for default হয়ে গেছিল আজকাল আপনারা তুলে
How long you were posted on the post of superintendent?
My lord, I was promoted to the post of superintendent on 1st of April 1995, and then I was promoted as a special officer.
So you did not hold the post of superintendent till your retirement?
No, my lord, I was then thereafter again promoted. My last, my lord, position was officer on special duty at the office of the legal remembrancer.
So OSD is on the same pay.
My lord, OSD would be, my lord, higher pay.
So that you have got.
That I have got. The only, my lord, your lordship, 2 pages, and my lord, the entire thing will be, my lord, I suppose, my lord, will be clear. Page 30 is the initial objection raised by the office of the accountant general, my lord. The 2 objections were raised. One, they say, as per entry made at page 12 of the service book, his pay was raised to rupees 2,135 on 1st of October 1991 by grant of increment. The next increment of pay was therefore due on 1st of October 1992, raising the pay to rupees 2,200, but it is seen that his pay was raised to 2,200 only with effect from 1st of June 1993, and the subsequent increment was granted on 1st of June 1994. The reason for such change of date of increment from 1st of October to 1st of June may please be stated. My lord, that part was clarified. My lord, this second part, the details as to how his pay was fixed at rupees 2,670 on 1st of October 1998 may be intimated. It may be mentioned in this connection that a promotion from a lower post to a higher post, both the posts having the same basic scale of pay, shall not be deemed to involve assumption of duties and responsibilities of greater importance in terms of Rule 54, subclause 1, subclause B of the West Bengal Service Rule, Part 1. As such, pay fixation benefit on such promotion is not admissible. My lord, to this, my lord, the legal remembrancer, my lord, clarifies, gives his clarification. And my lord, this is coming from the legal remembrancer at page 31, my lord. My lord, he says, with reference to the above noted memo on the subject mentioned above, I am to inform you the following facts for finalization of superannuation pension in respect of Sri Partoshan OST. 1. The entry from the marked portion of page 12 of the service book, volume 1, has been rectified and fresh entry has been made in the service book, volume 2. The fresh entry in service book will speak for the raised query under para 1 of your memo. Then the clarification is given with regard to the second objection. Sri Sen was promoted to the post of additional superintendent in the scale of pay of rupees 1,390 to 2,970 with higher initial start at rupees 1,435. His pay was fixed at 2,445 on 1st of October 1994 under the provision of Rule 42A of West Bengal Service Rule Part 1. Thereafter, Sri Sen was further promoted to the post of superintendent in the identical scale of pay of rupees 1,390 to 2,970 with higher initial start at rupees 1,480 on 1st of April 1995. His pay was fixed at 2,670 on 1st of October 1995 under the provision of Rule 42(1) of West Bengal Service Rule Part 1 in the light of the Finance Department memo number 11140F dated 9th of November 1995. Though the post of additional superintendent and superintendent being the same scale but different higher initial start, superintendent post is promotional post from the lower post of additional superintendent and carrying higher duties and responsibilities of greater importance. As such, pay fixation benefit has been allowed under the provision of Rule 42A sub-rule 1 of West Bengal Service Rule. So in the present case, the condition as laid down in Rule 54 subclause 1B of West Bengal Service Rule is not applicable. My lord, this is the legal remembrance clarified not once, my lord, thrice. And lastly, my lord, page 90, where he further clarified that all persons who were promoted to the superintendent post, my lord, have been given and no objection was raised by the Office of the Accountant General or the Finance Department. 7 except, my lord, in my case.
What is the basic scale of the pay of superintendent's post?
My lord, the scale is, my lord, 1,390 to 2,970.
So 1,000?
390.
That is the basic scale.
Yes, ma'am.
And what is the basic scale of senior superintendent? Of additional superintendent?
My lord, the scale is the same.
Then,
my lord, but with higher initial start, and my lord, as per 42A, my lord, it carries higher responsibilities. So, my lord, it is a promotional post. Lordship, kindly consider page 91, where a detailed explanation has been given by the LR.
no, whatever explanation, come to the rule. The basic scale is the same on both the posts. Now just read what Rule 42 says and why it should not apply. That is the only issue. It says an increment is to be granted when you assume that post carrying the same scale, whether that increment has been granted or not.
Notwithstanding anything contained in any rules elsewhere where a government employee holding a post in a substantive, temporary or officiating capacity to another post carrying duties and responsibilities of greater importance than those attached to the post held by him, the initial pay of such government employee in the scale of pay of the higher post shall be fixed at the stage next the pay notionally arrived at by increasing his pay in the respect of the lower post by one
increment. That is all you are entitled to. Where is the question when both the posts are carrying the same scale? How can you given a higher scale? You can't be given a scale higher than the post for superintendent.
It carried higher initial start. The difference between
it did not. We asked you 1390 is the same for both.
No, my lord. the initial with higher initial start, that is my lord, that has been clarified. Lordship,
We asked you what is the
paragraph
basic scale?
31, my lord, higher initial start at 1480, the post of superintendent. 1480.
Where is the order promoting you?
My lord, page 29. First paragraph is my case, my lord, my promotion. Sri Partho working temporarily as additional.
1390. How you are saying 1480?
But this, my lord, this post of superintendent had a higher initial start.
How do we know?
Well,
Just because you say so. This is a promotion order which you have accepted with open eyes without any objection. Therefore, they have applied 42A1.
No, my lord, they are applying 54. We are saying 42 will
Even
be.
if we go by 42A1, just see paragraph 1. If it is in the same, a post having the same lowest scale, then one increment is to be granted only. Whether they apply, see 54 is for temporary or officiating.
My lord.
But 42A1, even if we take that into consideration, the first paragraph, it appears that even if that is taken into consideration, then since the lower scale is one and the same basic scale, therefore you will be entitled
My
to
lord,
one.
I have, my lord, I had annexed before the tribunal, my lord, the fixation of two other persons.
Maybe we don't know if they have got something wrong. You are not going to get the wrong thing. The point is
Just page 91.
page
90.
90.
90.
No. Whatever you write, citing examples, that is not relevant. This is a
My lord,
promotion order.
this is not coming from me, my lord. This is coming.
Whoever may write it, that will
Officer of
not.
legal remembrance.
Whoever it may be, he is not the competent person for this fixation. Whoever it may be, however high he may be placed, he has no authority to get into this fixation. Why he is issuing a clarification?
Since the objection was raised by
The objection, but see your order.
Accountant
You
General.
have accepted this order in March 1995. Why 48A1 will not apply? Why you are objecting to 48A1? 34 of 35. No, this is page 34. P5, page 34.
One incorrect statement by the office of the
See,
accountant.
the post of superintendent carries higher pay start. It does not carry higher pay start. That is precisely what we have found. The starting pay is one and the same. 1390.
And his prayer was rejected. That's why it's not coming before the boy in the tribunal.
39.
Is, uh,
But this was page 39 was assailed before the tribunal. This is the letter, this is the rejection being aggrieved of which, my lord, I approached.
Yes, you have filed the OA in 2006 itself.
My lord.
Yes, that we have seen. He has filed the OA in 2006 challenging that. He says that please fix my pay as per the circular. Now, why do you say 48A1 will not apply? And how 54 will apply? 54 is for officiating, temporary or for permanent. Please see what 54 is. Pay on officiating appointments. Where is the question of officiating? Who says he is officiating? Come to the promotion order. Does it say officiating? Temporarily appointed to the post of superintendent. So it was a temporary appointment. It was not a substantial posting. Yes.
Please, kindly
Kindly see page 29.
temporarily appointed to the post. My lord, kindly sees the memorandum once, my lord, at page 78, the finance department memorandum.
Page?
Page 78, my lord, and the annexure at, my lord, page 30. Eta koto ki?
No, this is a temporary appointment. This is not a promotion order.
78, my lord, 9 is the annexure where, my lord, 2A is probably applicable in my case.
We will have to go by the facts which are obtaining in your case. Your factual foundation is based on this promotion order, which you call a promotion. They say it is a temporary appointed to the post of superintendent. So therefore, how can 24A apply? 54 will apply.
Yes, my lord.
There is no substantial promotion. It is a temporary appointment.
There is a, my lord, rider in 54. Unless the officiating appointment involves the assumption of duties and responsibilities of greater importance than those attaching to the post. That the, my lord, the remembrancer, my lord, clarifies that yes, the post of superintendent is, my lord, has higher duties and responsibilities. Page 13, paragraph 12 of my writ petition, my lord, I have clarified
54B. Yes. You have seen 54B. Where is the tribunal's finding on this prayer?
Sir, kindly sees the tribunal's order, the certified copy have been annexed.
No. Where is the AG's order? Objection?
My lord, AG's order at page 30, my lord.
Where is the AG's order?
My lord, page 30.
Page 30.
30.
30.
So 54(1)B, that is why they have relied. No, 54(1)B. Please read B.
Purpose of this rule, the officiating appointment shall not be deemed to involve the assumption of duties and responsibilities of higher importance if the post to which it is made on the
Same scale of.
pay as permanent post
So,
rather than a tenure post.
so your case is entirely covered by 54(1). Huh?
The finance department.
Where is that? Yes, you have shown that on page 34. But neither your order nor the order of the finance department records that it was a temporary promotion. Whereas a matter of fact, it was a temporary promotion. If that does not change much because the effect will remain the same.
This memo of 1995 have been cited by the, my lord, the LR.
How a memo will prevail over the service rules?
My lord, after ROPA 90, it's after ROPA 90, my lord, this memo was issued in 1995. And the, my lord, it says that after the circulation of the memo number.
When the memo was issued?
My lord, this was issued on 9th of November 1995.
How it can apply to your promotion of 31st March 95?
all the promotions in the higher post of superintendent.
Sir, how it can have a retrospective operation to operate from March if it is issued in November? Cannot. You were promoted on 31st March 95 on a temporary basis. So maybe that is why after issuance of that November memo, the others may have got it. Those who have been promoted after November 95.
My lord, it says, my lord, this memo of 1995 reads, my lord, the revised scale shall be given effect notionally from 1st of January 1986.
Correct. Notionally. So, no benefit. Therefore, no actual benefit is to.
Actual effect will be given from 1st of January 1988.
1988.
88.
And 95 memo saying that it will be.
Annexed that.
95 memo saying that benefit will be given since 88.
This is what the memo reads, my lord. Yes.
Where is that memo? Must be 98.
Page 78.
Page
78, my lord. Para, third para. The revised scale. The third paragraph. The last paragraph. The revised scale shall be given effect notionally from 1st of January 1986. Actual effect will be given from 1st of January 1988.
But these are two different things. This is for grant of a revisional benefit. This is not for grant of a promotional benefit. That's not, you are mixing up the two issues. How it can be? Whether you are claiming a higher scale by virtue of promotion or you are claiming a revision. The two are two different things. This is governing a revision benefit under the 1990 ROPA rules.
ROPA rules.
This has nothing to do with the benefit arising out of promotion. Your claim is that you are to be granted the next higher scale because it is a substantial promotion. That is your case. That has nothing to do with revision. Revision, by virtue of revision, even on the existing pay, you may have been in a position to claim higher, we don't know. For that, promotion would not be required. So therefore, we ask you, from the OA, it appears that you are claiming revision benefit. But you said no, I was claiming a promotional benefit.
No, my lord, revision. My case was, my lord, revision.
But revision to which next scale? Where is the pleading? Show us in the OA. What was the revisional scale for the post of superintendent, which has not been given to you?
Lord, kindly considers my representation at page 36.
Just tell us. It is from 1390 to 2970. That is the scale. According to you, this has been replaced by which scale which was not made available to you? Just find it. We'll come back. असाइनमेंट है ना इसमें असाइनमेंट है ना
Item number 5, for orders.
Yes, Your Lordship, I am for the respondent in this matter.
Who's for the petitioner?
Miss Anamika Pandey, my lord, she is there but in the court.
The learned senior, due to personal emergency, he is out of town. He has requested if the matter could be on Monday. I have also informed my learned friend.
As prayed by learned advocate.
Grateful.
Item number 117.
Led by Mr. Tapan Kumar Mukherjee in this matter. Lordship, in the last occasion, direction was to file our affidavit in opposition.
Oh, there is an direction for filing affidavit.
Lordship,
You have filed it.
so I'm filing today.
Get a copy.
You should go through it.
This order doesn't stand at all. I'll show them.
You want to proceed as it is?
Necessary, I shall refer to it.
Huh?
If necessary, my lord, I shall refer to this.
So therefore, we are asking you, do you want to file a reply or you want to proceed?
My lord, the opposition is not just now being handed over.
Therefore, we are saying it is better you go through it unless you want to proceed without a reply, then we
My
can.
lord, after a long strenuous effort, my lord, your lordship fixed up this matter today at 2 p.m.
We were not aware that there was earlier a direction for filing affidavit. So they have complied. So therefore, we are asking you.
My lord, I mentioned that there was a direction.
Maybe. We don't remember we said.
So, my lord,
if you want to proceed without filing a reply, we can proceed. If not, then there is no point.
my lord, in
Whenever
that
you
case,
want,
my
we
lord,
can fix it.
my lord, I can file an affidavit in reply, but your lordship will kindly be pleased, my lord, to fix it up on a particular day.
That's why we are saying you
Yes.
you tell us.
1 week after? My lordship has given a date, my lord.
Yes.
Okay, that's it.
Date पहले बताओ.
August. 11th August at 2 p.m.
You got 1 week. You wanted 1 week.
My lord, may I draw your lordship's kind attention to one thing? My lord, your lordship's list. Well, it is really hardly possible to read it. I am told that even your lordships cannot read this. It is printed in such a manner.
Now it has been printed half. That is why you are saying.
Yeah, the list. The
Size of the alphabet.
Font is very small.
Small because
nobody can make. If your lordship directs the register listing, it is he the only person who can do.
Because of the high
very
price of the
strenuous, my lord. I
high
am told,
price
my
of
lord,
the
your
list.
lordship also feel difficulty for that.
Because of the high price of the list, there is the agitation by the bar.
No. It is just
No, but
making it a
minimize
little
the
bold.
page, to minimize
Just
the page.
please bear with him for a minute. Yes.
There was a suggestion from the government that this is the cost for printing the list by the Saraswati Press. Then the
There was a suggestion from the government. Yes, I know. He will beat the drum of the government.
No, from everybody.
Suggestion.
There was
Suggestion. How many lists are being printed? What is the total necessity of the court? What is the total necessity? All these things were gone into by the learned the Chief Justice. And ultimately it appeared that there was a big ghapla. Ghapla. Necessity is 10. It is being printed 30. Market it. Charna. Golpo. If the latest, if it is made bold, no additional pages. এত এই যে পাতলা করে হচ্ছে ওইটাকে একটু এ করে দেবে ডিপ করে দেবে it is to be just made a deep one.
yes. Called it.
Item number 26.
I'm sorry, my lord, I'm disturbed.
No. We don't have the authority to do this. You will have to approach someone who has the authority. Did you find anything?
But I will call upon your lordship to revisit my lord 42A once.
42A. A1.
A1. Starts with my lord this non-obstante clause, notwithstanding anything contained in any rules elsewhere, where a government employee holding a post in a substantive, temporary or officiating capacity is promoted or appointed in a substantive, temporary or officiating capacity to another post carrying duties and responsibilities of greater importance than those attached to the post held by him. So, my lord, even if my lord,
Then what is the read the entire thing. Then what is to happen?
the initial pay of such government employees in the scale of pay of the higher post shall be fixed at the stage next above the pay notionally arrived at by increasing his pay in respect of the lower post by one
Increment, not the higher scale.
Increment.
There is no entitlement to a higher scale. You want the higher
My lord,
pay.
my entire case, if your lordship may kindly peruses my representation, is that when I got promoted to the post of superintendent, that my lord fixation was not done.
The fixation is not required.
So that increment.
We don't know that if you can show that you have been deprived of an increment, then only there will be maybe occasion to pass any order.
I cannot go beyond the representation that I have.
You have not said anything about increment.
Kindly sees
You are relying upon some letter issued by the LR which says that you are entitled to the next scale.
Upon my case, my lord, after
So therefore, the point is, what is the case you brought before the tribunal? That is all. So let us see what is the case you have brought before the tribunal. You want a revisional benefit. What is that revisional benefit you have been deprived of? You have not stated that as per revision, this is the refixation to be, this is the replacement scale for such and such scale, which has not, that's not your case. You are arguing about a promotional benefit. There is a temporary promotion we have seen from the order. Now you are on a different issue. That increment has not. From where do you get all this? There has to be a foundation in the pleadings. Otherwise, your client's case is whatever is there in the pleadings. It's not open to make out a case at the time of hearing.
Crux of the matter before the tribunal was also
Let us see. Let us see what was the crux of the matter. By submission, it cannot be resolved. You see what is your case. Roman 3, come to Roman 3, if we remember correctly. 4 creep. 4 is perhaps the narration of facts. I'm sorry, grounds 3. Ground 3 at page 61. This is your case. You want the scale. That's your specific case in the OA. It's not a case of being deprived of an increment.
scale is the same, my lord, as
Oh, it's not, sir.
my lord, the additional
Don't say that, please. Please don't say that. An increment is within the scale. A scale is a different thing. An increment occurs every year on a fixed date throughout the scale. And a scale is a totally different thing. It's not the same.
Scale is given in a particular pay scale.
And the increment accrues within the scale.
Within the scale.
From the lowest to the higher of the scale. So now you are saying that, but here you say it is a deprivation of a scale. So you cannot, the canvas.
My representation, the rejection, which was the basis for my lord.
Yes, so your representation, show us in your representation you have said about revision or increment.
My grievance that I made out before the my lord, the tribunal. The 36 and 39. 36 is my representation.
But we have just seen what you have written before the tribunal. Anyway, 39.
36 is my representation. My lord, the relevant paragraph is at page 37.
After allowing the annual increment, pay was fixed. So you have been granted the increment.
My lord, I am
The opening
from
line at page 37.
Thereafter, in the year 1994,
yes,
I was promoted to the post of additional
in the scale.
In the scale
yes,
of pay of rupees such and such with effect from
after earning annual increment.
After earning annual increment,
therefore,
the lower post of UDA. So from UDA to
yes,
additional superintendent,
yes,
I do not have a grievance. Now, my lord, I was promoted to the post of superintendent in the scale of pay of rupees such and such with a order dated 31st March 1995, but there are no fixation.
Just read slowly. But there are no fixation when in the said promotional post as a scale of. You are claiming a scale.
As the scale in the post of superintendent as well as additional superintendent were identical.
Yes.
After the issuance of the finance department memo number such and such dated 9th of November 1995, the pay in the post of superintendent has been fixed at rupees 2,670
Yes.
with effect from 1995 after earning annual
increment, correct.
Additional superintendent with such and such.
Now additional
At the time,
superintendent was.
there are no such action taken by the authority as well as your department. My lord, this is my.
We don't know. It's not clear. Sorry. There is no claim for increment. If you had claimed for an increment, you would have said so. You are harping on the scale. And that is why that para 3 you have stated that that scale is to be made available. That's never your case. We cannot allow you to make such submission unless we find any foundation in the case. It's not there.
Grievance is that
you come, read further, please further note that I was promoted.
Further note that I was promoted to the post of special officer in the scale of pay of rupees 5,000 to 11,275 with effect from the date of assumption of charge with a order dated 22nd October 1997 and pay had been fixed at rupees 9,025 with effect from 1997 as I received the charge on 23rd of October 1997. Thereafter, I was further promoted to the post of officer on special duty with effect from the date of assumption of the charge in the scale of such and such pre-revised as well as such and such revised with a order dated such and such, and my pay had been fixed at rupees 9,375 with effect from 30th of July 1998 with a order dated such and such, and I assumed the charge of the officer on special duty on 30th of July 1998.
There is
And
no claim for increment whatsoever in your representation. Not a word about it.
Only grievance raised was, my lord, this promotion to the post of superintendent. My lord,
That's what we are saying. That is only you want the next scale. That is the sum and substance why you have stated in ground 3. If you're OA, that is your claim. That is what you have come to the tribunal for. There is no claim for revision. There is no claim for increment.
Page 39 to 40 charging, sir. Page 39 to 14 charging, sir. Prayer and
our initials that are mentioned in ground 3 is, my lord,
An opportunity to respond. And in fact, the fixation order of the AG nor of the finance department deprives you of any increment. You have challenged 2 orders. Neither of them deprive you of any increment.
kindly the objection raised by the AG, my lord.
It's not for increment.
Wrong fixation of pay.
Correct.
Objection.
Correct. Wrong fixation. Just see what it says.
The details as to how his pay was fixed at rupees 2,670 on 1st of October 1998 may be intimated. It may be mentioned in this connection that a promotion from a lower post to a higher post, both the post having the same basic scale of pay, shall not be deemed to involve assumption of duties and responsibilities of greater importance in terms of Rule 54(1)(b).
Correct.
which I say,
That's the, so 54(1)(b) has nothing to do with increment. That's precisely what we are saying. 54(1)(b) is a different thing. They are saying as per 54(1)(b). You are not saying that you have not been given 54(1)(b). You say that 42(a)(1).
We say that, yes, my lord, we have been given this under 42(1), 42(a)(1).
So 42(a)(1) is contemplates increment. That means you have been granted.
Yes, my lord, that was the objection, and that is the reason, my lord, the question of overdrawl came. And my lord, 76,000 rupees were deducted from my salary.
They are
was directed to be refunded, my lord.
They just see we have don't find what you are saying from the reports.
This was the objection, the fixation, by giving the increment, which I say, my lord, was rightfully granted to me.
They have not denied or disputed the increment granted to you.
The fixation they are denying.
They have not denied or disputed the increment granted to you. You have not raised an objection that you have not been granted any increment. See the opening line of second paragraph of page 34. They have not interfered with the increment granted to you. They have said it is correct.
So found that due to promotion to the post.
Yes, so whether the next scale, that is the only issue. They have not interfered with the increment granted. They have said on scrutiny, it is seen that periodical increments have been recorded correctly. They have not sought to recover anything on the ground of increment. The recovery is because that note that you were showing us from that officer, that he is entitled to a next scale. That is the issue. That is a bone of contention. Where is that page 78 or something?
The memorandum, my lord.
Yes, no, the which has been written by the LR.
My lord, 90.
90. There's no issue of increment. Is there any withholding of increment also? Recovery on the ground of increment also? So what is the recovery has arisen because of what? He was placed in which scale?
Kindly see page 39 for a moment.
39.
Was not challenged. Was not challenged.
No, that recovery that you were trying to make, it is on what ground?
He got the higher pay scale.
It's 31. It's
Because of fixation.
It's 31.
Page
31.
Page 31, kindly see for a moment. Paragraph 1-2. Page 31. Sri Sen was promoted to the additional post of additional superintendent in the scale of 1,390 to 2,970, with higher initial start at 1,435. His pay was fixed as rupees 2,445 on 1st April 94 under provisions of 42 on part 1. Therefore, he was further promoted to the post of superintendent in the identical scale of pay 1,300, with higher initial start at 1,580 to 1st April 95. Though the additional post of
This
superintendent
fixation has been objected to by the finance as well as by the AG. This fixation of 2670.
So that is why, since it is an officiating temporary, 54(1)(b) will apply.
A1, my lord, kindly consider, my lord,
Cannot be applied.
from, my lord, substantial.
Cannot be.
Temporary.
It is a temporary.
Yes, my lord, that is what is provided under 42A1, my lord, kindly consider.
Yes.
Even if it is a temporary, my lord, one, my lord, covers that. My lord considers it to be a promotion if, my lord, it carries, my lord, higher responsibilities. And this finance department, my lord, memorandum clearly says that after re-examination, it is found not to be in order. My lord, which is not to be in order? That fixation which has been made, my lord, upon my promotion as a superintendent at rupees 2670.
Which is, this is a post of which group?
Not group A, not group A.
How do we know?
Not
How do we know?
head assistant, head clerk equivalent, LRS.
Where is that reading that it is not a? Show us. When you're relying on a rule, you have to comply with the entire requirement of the rule.
না পেজ না হ্যাঁ 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 টাকা ফেরত পেয়ে গেছি টাকা তো ফেরত পেয়ে গেছি না না ট্রাইব্যুনালের অর্ডারে আছে But in the memorandum of 1995, my lord, in the annexure, my lord, I come under the common category post 2A, head clerk, head assistant, other than secretariat. Your lordship, for other posts which are group A, my lord, it is mentioned within bracket group A. Other post, like in my lord, page 81, pharmacist, compounder, come clerk, within bracket, it is mentioned specifically group A of NMTP cadre. This is equivalent to head clerk and head assistant. My lord, cannot be group 1, my lord. Group A, I'm sorry. My lord. রোপার লাস্ট রোপার দুইটা 71 সালে এটা 1100 মাইনে ছিল হ্যাঁ যেমন 1000 টাকা বিশাল মাইনে ছিল কি বলছি তাহলে আপনি তো দেখেছিলেন আমরা দেখি ওটা তখনকার secretary to IAS category. IAS category. Up to joint secretary 2P. Head clerk, head assistant, বড় জোর খুব বেশি হলে কিন্তু
The opposition was filed. Like. Any reply was filed in the tribunal. Must have been, there is a.
Yes, yes. The 4 is the only
So the additional subtenant and subtenant both are in head clerk, head assistant scale. There's no difference. So there is no, what do they call it? What is that term? Higher initial start is not there for subtenant. After 81, it was merged.
It was merged,
A
yes.
common pay scale came into existence. Then there was a distinction drawn that if there is a higher initial start for some post, because just to maintain the difference between the two posts, a higher initial start was given. In 91, it has all been amalgamated, and your promotion is much after 90. It's not a promotion. It is not a promotion. The order is clear in its intent. It is an appointment on temporary basis. It's not a promotion. Huh? It has been omitted.
Is the reason it was re-clarified in 1995.
No, there was no higher initial start. That is what you are saying. In ROPA 90, there was no higher initial start in the same scale of additional and subtenant. So it was identical in the 90 ROPA. Yep. This 42 that you are relying upon does not.
2A1, man.
Yes, it does not say anything about higher initial start. So this is in only if the posting is a promotion on a post carrying higher duties. They say this is not the situation. It is not a post carrying higher duties as per their Whatever is there in
the
the service.
reply, they say nothing, my lord. They have only clarified the position from ROPA 80 to ROPA 90.
No, they have,
And-
you have yourself said, that they have taken a stand that it is not a promotion carrying higher duties. That is your specific government.
My lord, this is my specific averment that this is a promotional post carrying higher, my lord, responsibilities.
Yes. But you are not able to show from anything. And every cadre has a list of promotional and feeder posts. If this was a promotional post, you would have come forward with such a chart showing that it is a promotional post. You have not, apart from making a government, there is nothing. You have to establish that it's a higher post.
All along, my lord, from the post of LDC to UDC to additional.
We are not on history. We are not on history. There is only one movement involved. There is only one movement involved, which is relevant from additional superintendent to superintendent. Whether it is a promotion, how it can be a promotion when it is carrying the same scale of pay? How can it be a promotion if it is carrying the same scale?
Kindly consider, my lord, they did not object that this was. not a
Forget about,
promotional.
we are not concerned with what they are saying. How do you make out a case? If it is carrying the same scale of pay, how it can be a promotion? How it can be a promotion? And what is the foundation? Again, we are asking you. We had asked you earlier also. For attracting 42A, it has to be a promotion on a higher post, assuming higher responsibility. There is no promotion.
That particular notification, if I be allowed, my lord, I will find.
No, not now, sir, not now.
That this is a promotional post.
This
my
is
lord.
not.
And the office,
Nobody is saying it's a promotional.
The office is saying this is a promotional post. They are not denying that this is not a
Oh,
promotion.
they have in so many words said that it is not.
My lord, they are on the fixation. My lord, otherwise of.
Nowhere. The very order that you have taken benefit of at page 29 does not say it is a promotion. That is the foundation on which your entire case rests. If there is no order of 31,395, there would have been no dispute. 31,395 does not say it's a promotion. Does not.
My lord, appointment to the post of superintendent, which is the, my lord, of the
In
high-
the scale.
from
Yes.
from the post of additional.
And there is no difference in the scale. So therefore, it cannot be a
That is the
promotion.
reason, my lord, kindly sees, my lord, 95 memorandum gives the
have seen.
clarification because it was omitted.
We have seen enough. Yes. Take down. Third learned advocate for the petitioner.
27.
Ship, on behalf of the Mr. Bhattacharya, his leg on the other courtroom, code number 35. So kindly fix this matter on next week, Your Lordship.
Yes. It asked you to verify. On 17/6/25, we have passed an order. Whether you had raised the issue of limitation. You are always taking in as adjournment. Every date. Why? You are not interested. Every date you are taking a adjournment. Sorry. Yes, what we had asked you on 17/6/25. No, therefore we had asked you that whether you had filed a reply raising an issue of limitation and whether the reply was filed on the date on which the application has been dismissed or on an earlier date. When did you file the application? Paragraph 4 of paragraph 4 of the OA. We are asking you, when did you file an application that it was raising the issue of limitation? When have you raised the issue of limitation? The OA has been dismissed on the ground of limitation. What is the prayer in the OA? Nineteen to 14. Page 19. P3. Page 19. P4. This is does not appear to be the rejection of 19 to 2014 order. Where is the 19 to 2014? Page 20. That is a tight copy. Here, which file? First OA filed, second OA filed, second OA was filed, the first was withdrawn. Of limitation of where is the order of withdrawal of the first OA? First OA was withdrawn, OA 970 of 15. No, that should be 12/5/2017. Which page it? OA 970 of 2015 was filed for the same relief. Then this OA was filed in 2016. After filing of this OA, the earlier OA was withdrawn on 12/5/2017, leaving the issue of limitation open. So where is this order of 12/5/17? What does it say?
Copy. Lordship, I have the copy of the order, Lordship.
Please show us. (12/5/17) order. February 19. It was rejected. But that is challenged in the present way also. Both way. First OA was filed by the son, second OA by the mother and son both. Both together. (21). So he is relying upon the subsequent representation. He has filed another representation on 24/6/2015. And the OA has been filed on which date? Second OA? 22nd? So therefore, he is saying he has filed a representation in June 15. That is his ground. That 24/6/15 is the representation filed by him. And therefore, according to section 21, he will be entitled to 1.5 years. We have it. So 21B, 21(1)B. The final order has been passed, that is all right, but his final order is of which date? Yes, rejection. Then it had to be made, the application had to be made by February 15. No, even if condonation is filed. No condonation is. Listen. Yes, representation was rejected in February 14. Thereafter, there is no rejection. It is in the OA he has said this rejection order. 19 February 2004. By 12. Deaths. All within time. Rejected on 19 to 14. 14. Rejection. We filed an OA challenging the filed an OA in 2015. That OA was filed within maybe. But subsequent OA was filed by mother and son both in 2017. No, sorry, in 2016, second OA. 1300 of 2016. After filing the second OA, objection was taken by the state that he has filed two OAs for the same. Then both the matters were brought in. First, said I don't want to press the first one. So first one, but issue of maintaining equity was left. That issue has not been overcome. Now challenging an order of February 14, whether the OA filed in 2016 was maintained. Sought and rejection is on what ground? Minimum age not qualifying. And what was the time for filing application at that time? 6 months or 2 years? Death is of December 2011. EMP. What was 6 months or 2 years? Yes.
Page 19, Lordship. That was they are considered. So, the learned court, they consider their financial consider.
Yes. But it has been rejected. Which EMP is applicable in December 2011? Which EMP was applicable? So 2008 circular, what does it say? It is 251. No. 2008. 30. Page 41. Six months. And minimum age is specified.
December
6 months. Seventeen and a half years then. So we'll consider it tomorrow. Mr.
Number 28. Respondent number 1, 2, and 4.
Last person Lordship was directed to serve the copy to the daughter of the petitioner. Was that was the response.
Respondent number 3. Still unrepresented.
She is not interested.
Hmm?
She is not interested.
Not interested. Where is the service? Where is the envelope?
My lord, envelope is
Why you have not? You should have given it. Can be. 4331. Yes. It says Madhujana is somewhere is posted it. Here it says item delivered to Madhujana. Oh, it has been returned. So there is no service. Why you are saying it has been served?
Sir, my lord. Can you tell the delivered location, my lord? Raghunath Bilso. And then, but it revert back to me, my lord, on 47/2025 at 3:49.
It's been given to you.
Postal, not my lord. The delivery location, my lord, delivery location, my lord, appropriate, that where I am sending the post. That is, my lord, at the Raghunath. Thereafter, it has reverted back to me due to, my lord. And it says that
Therefore, there is service. If address is not there, it will be a valid service.
But I don't have any other address.
We are not asking you that. We are asking you how you have said it has been served. When the address is not there, it has come back to you. Therefore, it is a service. A unique submission.
Department himself has sent.
We are asking you why you say it is a valid service. How you can say it is a valid service when where you have sent it, the address is not there, she has left. You are saying it is a valid service.
Refuse, my lord.
So now the previous you are taking up. Just now you said it has been served.
Yes, this is previous one prior to this order.
Previous one, if it was accepted, where was the question of issuing again?
No, my lord, previously because my lord, that order passed on 2nd of July. Prior to that, I have sent. Thereafter, again, I am sending after passing this order, my lord.
Correct. So now there is no service. Don't say it has been served. Why you say it is served when she is left? There is a note that she has left. This is very unfortunate. Why should you make such a submission which is contrary to the record? Left means served. Show us the law. You have thought out your submission, so show us the law. That left means served. Show us. You have made a very thoughtful submission. We have understood. Now show us. So therefore it is served. Show us. Please show us. Then it is to be taken as valid served. Why you are saying served? Unique submission and you are repeating the same thing. Instead of expressing any remorse, you are repeating the same thing. First, you have made a submission contrary to record, and then when we have pointed out, you continue to justify. You have no remorse for making a submission contrary to the record. At least have the courtesy to say that it is by mistake I have made this submission. This is a false submission, sir. That's why we asked for the envelope. Why do we have to look at all these things? You should have told us that, look, this is the position, that we don't have any other address. Why you think that you will make a submission and it will be accepted? And how you are saying she is not interested? Do you have instruction?
We have informed her that this is the position of this case, since her father has transferred already processed. No. And this is the address of the matrimonial house.
This is the address.
One time they refuse it, one time they say that they left. This has been happening for the last 1 year. My lord will kindly see the record.
They have not appeared in the tribunal also.
No,
tribunal, her
Oh,
father was there.
substitution has taken.
Of 3 affidavits show us that it has been refused. Yes. So, from the 3 affidavits show that he or she has refused. Refused has not been. So,
Sir, you are, this is too much.
and how can
This
you
is
say,
too much.
how can you say that she or he is not interested?
All submission contrary to record, false submissions in a court. What no?
My
One after the other false submission, one after the other apology. Very good.
my lord had instructed me to take instruction whether she will be
Will
representing.
furthers the wakalatnama?
So everything you say from now, we will have to examine
All other
every
except-
page, whatever you say. Rather than relying on submission of a lawyer, now we will have to check everything you say. First you said served, and now you're saying earlier refused, even that is wrong. Very unfortunate. Very unfortunate. And after every wrong submission, you say sorry. Left is not a service. You have to.
But it sees the endorsement of the postal receipt that is refused. Thereafter, I'm not making false submission, my lord. Rani Chakraborty, kindly seize the address, my lord.
No, but this was prior to subscription.
Yes,
How you
yes,
can
ma'am.
serve prior to subscription?
Yes, ma'am. That is the issue.
Cannot.
That is the issue.
There is no service. You file it just like that. Put it on a. Give it. After 4 weeks, আজ কত? আজকে হচ্ছে 5th. Let the matter appear on 3rd of September. Copy of the death certificate of Mukul Mukherjee. The original respondent has been furnished. Let it be kept with the record. Fresh step to hand. Sorry. Then immediately.
Item number 29.
My lordship, I'm appearing for the petitioner side, my lordship. My senior Bikashana Bhattacharya is right now, he is in Supreme Court regarding the DA matters. So my lordship, kindly, my lordship, take this matter after 2 weeks, my lordship.
In that case, Panchayat employees of the Jala Parishad, rule making authority is the Jala Parishad, controlling authority is the Jala Parishad.
Have you filed anything? You have filed it.
Have you served them a copy also? When you have filed the compilation?
When
You have served a copy on them also. You have got a copy. This you should be knowing. Why don't you know? This is no way to appear. Hmm? No, the issue is which is the authority. Is there any tribunal under this law? Why High Court?
Because there is no notification under the Administrative Tribunal Act, so far as employees of the Jilla Panchayat or Panchayat. Panchayat. First, then, and Commissioner of that, I think give power and power.
And who pays their salary?
Jilla Panchayat, not by the state government.
They are given the same scale as the state government.
But so far as employees of the state government framed under Article 309 provision, and for the Panchayat employees are framed under Article 162.
Who pays the salary according to this compilation? Who pays the salary? State government.
Head of the Panchayat, head of account is the budget, is the head on account is the budget. Whatever the collection they have got, or just like a party, there are certain collections, then conduction of that plot.
You come to the compilation that you have given. Page 3. Roman 4. Parishad Accounts Officer. Who is he? Who is he? To be appointed on deputation by the state government from amongst officers of the West Bengal Audit and Account Service. So he is a state government employee.
Or they will be state government employee and they will get the salary from the Jalapuchal Park.
The tribunal has refused to entertain.
There is no notification issued by the state government. Only a state government employee.
And petitioner is holding which post? He is also deputed from the state government.
Sure. But should also and their retirement benefits separately. Customer service, their retirement benefits not be applicable.
ECRB is not applicable.
The Rupar so what is the Jalapuchal consultancy and Rampal, their base here also revised.
They are within the lower division assistant. Lower division assistant. Post is assistant coordinator. Whether they fall under lower division assistant or upper division assistant. Herein there is no post as such, assistant coordinator. There is office superintendent, head assistant, upper division assistant, lower division assistant.
Coordinator.
They are treated as non-government. What is a Zilla Parishad?
Then
So every village is represented by a Pradhan. And the Pradhans will form the council. What is called Panchayat Samiti. No, above that. Panchayat Samiti. And then Zilla Parishad. At the district level. So Zilla Parishad is also a rural or local body. So it is not a state. So every department has separate ministry. Correct. Here also commissioner exercises control over everything.
what's the same thing. There is no person elected by the public, then that person or the mayor is elected by the members.
Under the Panchayat Act or the Municipal Act, there is no forum prescribed for the service disputes. (323A), what does it say? Just read. Appointed to public service and post in connection with the affairs of the union or of any state or of any local or other authority. Local, this is a local self-government, this is a local authority.
All these was from 19.
Therefore, notification may not be required. We don't know. We are just on going through it. Prima facie, we find notification is required for those who are not within this. Then a notification is required under section 14.
14 and 15.
14 and 15 for the state.
State and central.
Yes. So therefore, local authority. It says the constitution says local authority. Just read it in one breath. You read it without breaking it.
Parliament by law provide for the adjudication or trial by administrative tribunal. Schools are
Appointed to now slow public service.
Yes.
Post in connection with the affairs of the union or state or of any local or other authority. So this is a local self-government.
Clause 3.
323(3).
323A. 3.
There were two. 323A. 3. How is that relevant?
See, 243. See. Punjab came under that to the constitutional authority after the amendment made in 1992. What is the age also? Tax once for the Punjab.
Any provision under Part 9 regarding the staff of the panchayat? Only the elected representatives.
Regarding election,
Obviously,
what is
the democratic process only.
not development?
Correct. So we are not concerned with those persons. In this case, the tribunal is not concerned with those persons who are covered by Part 9 of the Constitution. The tribunal is considered by the staff of the.
Staff of the Jila Parishad or Panchayat.
So therefore, we asked you whether any provision is there in the Constitution for them.
For the excise person, there is no discount.
No. We will see. Let the senior advocate be here. We'll see.
And Madam,
You will have.
first case, it will be the first case in Bengal, Calcutta High Court. If Panchayat are decide the order.
We don't know. We don't know. We are what we have seen right now. We are saying we have not heard the petitioner's advocate also. But
According to them, it's they are covered under the 323A. Only heard that tribunal has been given.
no, but I think the last day you were telling us that till now not a single case has been decided by the tribunal. Never.
No, not a single case has been decided by the tribunal. So Panchayat is concerned.
They all come directly to the High Court.
Or disciplinary action, or retirement benefit, or appointment at compulsion ground, directly to the High Court to the total.
And the respondent is State of West Bengal.
State of West Bengal, but Panchayat.
Obviously, in some cases it is State of West Bengal Home Department. In some case it is West Bengal Panchayat Department. In some case it is West Bengal Irrigation Department. Department does not make a difference.
They have got separate death of retirement benefit rules 1985.
Maybe.
Yeah. And they have got separate rules.
You have separate provision for police service also.
Yeah. No, police service, about the response service.
No, there is different provisions also under the DCRB. For their pension, for their compassionate appointment also there is a. No, their compassionate appointment is dealt by another set of provisions.
No.
Appointment under the exempted category is under which EMP?
Same circular.
Same circular. Anyway, so they have any compassionate appointment in Panchayat? Not covered by the labor department. So who has issued that scheme?
Separate allocation for the Jala Parishad.
See, the only thing we have to see is whether it is covered by 323A or not,
Or the 1985 Act.
or the 1985. These two things we have to see. Now, so far as Article 243 and the various sub-clauses or Part 9, we have not found anything in that relating to staff of the Panchayat. Not there.
That's why the government has not to take up.
That's why we are saying.
And it's doing it. They will have to do
What is the situation in other states?
it.
They are all moving the High Court. You have any information in this regard?
From Allahaba. They directly have to.
Directly to the High Court. They don't approach the state administrative tribunal.
Also in Ahmedabad, residential regulations have power. They have got Panchayat regulations. It's called not act. Legislative power has to be the no. Panchayat regulations there and their employees directly approach the High
How much time you want? How much time you want? As prayed by
Court. Upon 1995 Code SSC, page 8.
95 4 SCC.
Page 8.
They have relied.
The Local Boards Act.
What does it say?
Local Boards Act.
Local boards.
Act. In Karnataka.
1995 volume 4 SCC.
Page 8. A Panchayat secretaries. Here, the Panchayat secretaries are appointed by the state government. They shall have to go to the tribunal.
Secretary.
In every Panchayat, there is a secretary. Or it's called executive officer, appointed by the state government.
That's why we said that accounts officer is also appointed by the state government.
But they shall have to approach before the tribunal. Because they are not for administrative control of the Panchayat. They are on will be the direct employee of the state government.
And in this case, petitioner is holding what post? He is appointed by? All right, we'll see.
Your Lordship, I appear for the petitioner. I am led by the learned ASG. He's down with high fever today, Your Lordship. I'm praying for not today, Your Lordship. Lordship, if it can be placed next week, Your Lordship, Tuesday week or Wednesday week.
Yes, you were supposed to file an affidavit. We had asked you a specific query based on the submission advanced by the learned ASG.
Yes, Your Lordship.
That what is the status of the other claims of the legal heir?
Status of the other claims, Your Lordship.
Yes, we have recorded this order in the
Yes,
present.
yes.
So what is your instruction on that?
Your Lordship, an affidavit has to be filed in that, Your Lordship, in that regard.
This is order of 25/6. What other claims are there? Under what other heads are any dues?
My lord, when I was, my lord, removed from service, I was a temporary servant. More than, my lord, long period I was under temporary service. So according to, my lord, rule, my lord, I am entitled to get the family pension if they do not want to proceed against me. Because they says that I am not a employee. My father was an employee. So employee,
Therefore, we are asking you,
yes,
based on the submission, learned ASGI submitted that the tribunal's order is nullity. Because how a proceeding can be conducted against the legal heir of the employee? So if no proceeding can be conducted, then what is the dues? Therefore, we are asking you.
my lord, I am entitled to family pension and the provident fund gratuity.
Family pension, provident fund and gratuity. And was the punishment order passed while you were still alive? The
No,
father,
no punishment.
father was
There is no punishment on record.
after his demise.
After his demise, no punishment on record.
No punishment has been passed. That is why it was remanded after quashing the
Yes,
punishment
my
order.
lord, the punishment order and the appellate order was set aside, and matter was remanded to the.
When? It was remanded during your lifetime, father's lifetime, or after his demise?
First of all, come to the input order.
Please tell us, sir. Because they have to file a affidavit in this regard. And the date of unfortunate demise is? What is the unfortunate date of demise of your father? Right. You want 1 week's time, all right. As played by learned advocate for the Union of India. Under what heads? Yes.
Fixed time.
1 week. You want 1 week.
So can I make it 2 weeks? I will have to collect the.
As jointly paid list after 2 weeks.
Thirty-one.
31, my lord, I am for the petitioner.
Yes.
I am for the respondent, my lord.
Lord, on 25th June, your lordship's pleasure was to direct that file a supplementary affidavit. Next thing there too, the reply filed by the they did not prefer any rejoinder. Written notes of argument.
Complete records.
of the tribunal.
The other records are with the writ petition, but this record was not available in the writ petition. The other records are in the writ petition, but this record was not found on that particular.
We have directed that some documents which are relevant for consideration and the complete records of the tribunal be placed on record.
Yes.
So now after this, the complete record is on. The complete record of the tribunal is there.
That is minor.
You seem to be doubtful.
No, I am not doubtful.
Yes.
The rejoinder could not be annexed, my lord. That's why, my lord.
We are asking you a simple question. Before we proceed, we want the records to be complete. Therefore, we are asking.
My lord, as per me, my lord, the record is complete.
All right. You are appearing for?
My lord, he is my junior.
I am for the respondents, my lord. Only one respondent.
Yes.
My lord, record is not complete. They have not annexed the original application with annexures, the reply, rejoinder.
Original
They are
application.
not with annexure. Original application they have filed. There is so many annexures in the original application.
That is there.
No, that is not there. All the application you have not filed. All the annexures.
Possibly, I have received the annexures, whatever.
A supplementary affidavit they have filed that was not served also.
My well, it is their reply there.
You are the writ petitioner.
Yes.
You want us to consider the matter.
Yes.
It is your obligation to place the entire records on the in the writ petition.
As per me, my lord, possibly this is the
Possibly is not an affirmation of what you are saying.
If anything comes from your lordship, my lord,
That is, there is nothing we want apart from the tribunal's records. Have you said in this affidavit that now the record is complete?
that particular.
So every date after a few minutes of hearing, we will ask you to file another supplementary affidavit. Is this, you want your matter to be considered or you don't want it to be considered? If you don't want, leave it.
No, on the basis of the.
Why are you saying his reply and his reply? You are the writ petitioner. You have to file everything.
I have filed it. I have filed it. Lordship, kindly hear me for a moment. But the writ petition was not previously with me. I have been appointed subsequently, my lord. The writ petition was not happily drafted.
This was over on the last date.
Lord,
Last date you had told us this.
That's why, my lord.
Yes, therefore, we granted you an opportunity and we have specifically said that the complete records of the tribunal would be placed on record.
My lord, that is true, my lord.
So where have you said that now the records are complete?
That Lord, only.
What is this, sir? This is not
that
the
line
way.
has not been included.
This is not the way.
Lord, in that event, my lord, the record is more or less, the record is complete as per me. But if my learned friend opposes,
Let us see. And he is saying you have not served also.
twice we tried, but anyway, that excuse will not do. Lord,
we are seeing him in court every day. He is not a new counsel. Even I recognize him in 1.5 years. You should be recognizing.
Lord, we also recognize him, but then whenever we made an attempt to serve him, he is somewhere missing.
Give him a copy. Let a copy of the, yes, take down. Let a copy of the affidavit
মামলা ওরা বলছে আর আপনিও লাফাচ্ছেন না না মালট আই এম সরি মালট
If it is at the top record,
be 13th because 12th, but can it be 13th?
on 13th.
এটা এমনিও থাকবো না 13 থাকলো হ্যাঁ এত ছেলে খেলা করলে রোজ এসে দেখো না না
Not in the next matter, unfortunately, the petitioner has died last week. File subscription application. Item number 32.
Item number 32.
This matter I am appearing with the respondents.
You are the advocate on record, Mr. So and so.